This regularly scheduled meeting of the Board of Architectural and Engineering Examiners is taking place in Conference Room 1A of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. And notice of this board meeting was posted on the board website on March 30th, 2015. And I would like to remind all the guests to please sign in. Thank you. All right. Need to do a roll call, Wanda, please.
Susan Ballard.
Here.
Hal Balthrop. Here. Wilson Borden. Here. Robert Campbell. Here. Jerome Headley.
Here.
Philip Lim.
Here.
Bill Lockwood.
Here.
Rick Thompson.
Here.
Frank Wagster.
Here.
Ricky Bursai.
Here.
Laura Reinbold.
Here.
Stephen King.
Here.
Full house.
Thank you, Wanda. Next on the agenda, we'd like to acknowledge our guests. Would you please stand and give us your name, and you'll be coming up on your professional society reports later too.
Casey Anderson with the engineers. Ashley Cage with AIA.
Morning, thank you. Are there any announcements? Not that I know of. Okay. Review the agenda for changes and/or additions. Are there any comments regarding that? If not, we'll move on. Next on the agenda is the consent agenda. John Cothran, this is yours.
Page 85 on your iPad, you have minutes from the February 2015 board meeting for your approval.
I move to approve.
Second.
We have a motion and a second. Any discussion? No discussion. All the motion approved signify by aye.
Aye.
No, the same. The motion carries. Next on the agenda is the professional society reports. Are you through, John?
Oh,
I'm
you got
sorry.
the staff complaint report also.
Okay.
Yeah, that's on page
That's
99.
right. I'm sorry. I jumped ahead.
Yeah, page 99 on your iPads. These are all complaints in which the respondent was disciplined in another jurisdiction. The discipline was less than a suspension or revocation. So in accordance with board policy, we issued a letter of caution and recommend closure. You can vote on these as a group.
So move.
Second.
We have a motion and a second. Any discussion? All in favor signify by aye.
Aye.
Opposed? No. Motion carries. Thank you, John. Now we can move on to the professional society reports.
Ashley Cates. Do I need to go to a microphone?
I thought there was a microphone.
Perfect. Thank you, John. My name is Ashley Cates, Executive Vice President of the American Institute of Architects. Today, I'm just going to briefly go over a recap of what's happened since the February meeting. We had our Day on the Hill in early March. There was a snowstorm that came in, so luckily our members were able to visit with the legislators on several different issues. Some of those issues and pieces of legislation covered fire codes, the state procurement legislation that the architects and the engineers and the contractors were able to have amended where our services were taken out of that legislation. So that's a very good thing. I can let Candy report on what happened to it. In addition to fire codes and legislation, there is some legislation regarding energy codes. That bill is not being moved this year. So overall, I think we've had a good session. There was one bill that we were fighting with the Tennessee Fire Coalition regarding fire sprinklers in townhomes. This rings a bell. And essentially, the amendment was put on there where the local jurisdictions will have to adopt a code for the fire sprinkler requirements. And there was testimony given, and there was pretty good testimony given by the Knoxville fire chief. And they all had the legislators all had their out and their way to say, we want to be able to have the local commissions adopt the fire codes again. So that was kind of a bummer for us, but overall, we had a good session. We're hoping to recap. Sorry. We're hoping to, but it winds up at the end of April. So the next thing that we've been working on, the state has, the AIA Tennessee, the Executive Committee and Board, is the state contract revisions with the state architect. So we are down to the final nitpicky, what we can live with and what we can live without. And there are several issues that there are still very big sticking points. So we'll see how it goes. I know that this is the first contract revision that we've had with the new state architect. Things may have been differently with the previous state architect. So hopefully I'll be able to report back in June that everything is going well and we're going to have a new contract adopted by the State Building Commission as of July 1st. We're also, there was some issues with TBR putting out some RFQs that included basic additional services within basic services. There were 3 that were put out, and we had a meeting with Tennessee Board of Regents just a few weeks ago. It was about a 5-hour meeting, and we requested that they go back to the way things have done for the past 30 years until we can figure out the new contracts. So I've heard, we never got a reply from TBR, but I've heard that meeting put a lot of pressure on them, and so we're hoping that the next RFQ will reflect the way the previous RFQs have done. If not, AIA will be back over there. So that's really the big ticket items that we've been working on since February. Convention's coming up. It's going to be in Knoxville this year, so July 29th through the 31st. We'd love to see you all there if you can, and I can send John more information on that. I'll also send John the letter that we provided to TBR before our meeting, that we requested a meeting. So does anyone have any questions, specific questions? Or all right, thank you.
Thank you.
I'm Candy Toller with the American Council of Engineering Companies of Tennessee and the Tennessee Society of Professional Engineers. And this will be the last time I say that to you. Because in 21 days, I will no longer be the executive director of those 2 associations, and Casey Anderson will be. It's been fun. I've enjoyed it. I enjoyed my 4 years here with you guys, and I will miss you, I promise. Some of the issues, like QBS, maybe not, but I will miss you. Ashley gave you a little bit of a rundown on legislation. There were a couple bills that we really had to work hard on, and one of those is allowing local exempt jurisdictions to have building codes that are less stringent than the state code, and that's been deferred until 2016, which means it's not my problem anymore. But it's Casey's problem and Ashley's problem. And the threshold for public works requiring an architect or an engineer has been increased to $50,000. It was in Finance Sub yesterday, and I did not notice. I didn't go look to see if it was reported out, but I assume it was. And it's already passed in the Senate. And those are the 2 big ones that we were concerned with, I think. And, well, there was the other bill by Ron Lawler that we knew was a caption bill that would allow for changing the seismic code in Memphis. And that, too, has been deferred until 2016, which means it's not my problem. Okay. And we're having our engineers conference on September 17th and 18th, and I hope the engineers at least will plan to attend. As a matter of fact, John, we haven't asked you yet if you would like to make a presentation. We would hope that you and some board members would do that like for an hour and a half or something.
We did that last year.
You did that last year. You think there's not enough issues before this board to,
Oh, I'm sure Hal could come up with something to talk about, right? Somebody can, yeah. I'm sure we could.
there are always issues, and they always want to ask you questions. It's always helpful to the engineers, especially for you. to be
We
there.
would not mind doing that as long as we can get a little bit more favorable time slot. Friday afternoon at 3:00 doesn't seem to be a real good time for us.
But no, you finished at 3 o'clock.
Well, same difference. It's 3:00 my time. Didn't matter.
And,
Yeah.
and people stayed to hear you, Robert.
I think they stayed to hear Hal, but whatever.
Is that what it was?
Yeah.
Actually, you didn't stay, did you?
didn't
Because
stay,
you
no.
Robert wasn't there.
He left.
Yeah,
It was Hal and Laura.
but we were between them and golf, and that's not a good place to be.
Anyway,
I think that falls during the, I don't know if it's on our calendar on here, the CLARB annual meeting. Usually it falls that same week as the CLARB annual meeting.
What's the date?
September 17th and 18th.
I don't think the full calendar's on here, but anyways, that's typically the problem that I have. That's why I can't usually attend that, but I'm sure some of the board members would be happy to do that.
You just
Wouldn't
want
you?
a better time slot, huh, Robert?
Better time slot.
Okay, we'll see what,
And-
I'm sorry, Casey will see what she can do.
Casey, take care of that for us. Okay, it's obvious. Well, I would like to, unless there's other questions, just say a quick word. Are you done yet? You acted like you were done.
Yeah, I'm done.
Well, you acted like you were done. Are there any questions? Okay, well, I'm just gonna say something on behalf of the engineers, if I can have president's privilege on that,
Absolutely, please
or
do.
chairman, or whatever you are now.
Yeah.
Candy, I want to thank you on behalf of this board. I want to thank you for your service. Some of it, I know, has just been extremely excruciating. Anytime you're dealing with people like ourselves that think in a linear fashion and having to deal with issues that are circular in nature, you've helped us kind of bridge the gap. And I want to thank you very much for what you've done for us as a
Are you
board.
trying to make me cry?
Listen, I'm trying to turn a new leaf here, okay? Trying to help my reputation some. Actually, Hal's paying me $5 to say this, but, oh, it may be in, but I do want to thank you for what you've done. Just quick history, and this is why I reckon my connection with Candy, my dad was on the committee that hired Candy, and so I've always remembered that, and I always remember what he said. Do whatever the redhead said, and I've tried on some level to do that. So, but honestly, you have given us tremendous advice. You've helped us navigate through things that we may not have understood all the issues and all the nuances of what was going on. And you've presented to this board great information and again, given us tremendous advice and great help. And as you go into retirement, I want you to know that it's a job well done.
Thank you.
And that you've helped our profession and you've helped me personally, and I would assume that everybody, all the engineers anyway, because we're usually in some sort of fight with the architects about something, right?
Right.
Okay, so you may not have helped them as much, but I want to thank you for the engineers of what you've done for us professionally and personally, and I just wish you great retirement. Don't be a stranger. Every once in a while, come maybe and sit in the back. If you're just walking through downtown, sit in the back of the room and laugh at us as we struggle through issues or something, that would be perfectly great. And I just want to thank you from this board for
Thank
what
you,
you've
Robert.
done.
Your father was the first president I worked with, too.
Well, I don't know what that says about either one of us, but,
I thought he had good sense.
well, he may have. He may have.
I mean, especially when he told you to do whatever the redhead says.
Yeah, but my mom's redheaded too, so I think that came along with it.
Thank you, guys. I really have enjoyed working with you, and you guys haven't been hard.
Now you can cry.
It's hard to follow, Mr. Chairman. Good morning. I'm Nathan Ridley. I'm here on behalf of the Tennessee chapter of the American Society of Landscape Architects. I, too, owe Candy a debt of gratitude. She has counseled me on the importance of working together to protect the built environment, what y'all do every day in the public policy arena. And I know it's hard for my landscape architects, and I suspect it's hard for y'all because the switch is either on or off sometimes for y'all. And you're kind to say it's circular. I'm not sure there is a pattern to the political process or the public policy process, but y'all's participation in that and that of your colleagues is vitally important to the folks, the 132 members of the General Assembly making good decisions. Yes, they can. Our legislative friends are almost done. They're in serious. Y'all remember the only bill they have to pass is the appropriations bill, and they're working on that right now. The revenues have been pretty good this year for state government, so I don't think, John, there'll be a raid on reserve funds for boards and commissions across the state, which always makes John happy. So that is a good thing. My suspicion is they'll be finished about the 23rd or 24th of April. They're kind of rushing to a conclusion right now. And that's always the scariest time for the folks that do what we do because they suspend all the notice rules. Typically, you know a bill is going to be filed or it's going to be heard, but kind of all those rules wander off the reservation now as they hurry to get finished. So you have to watch particularly carefully this time of year. Towards the end here, it's Landscape Architect Month. Projects are underway across the state in various communities and particularly in the schools to help folks recognize that and what the profession does. And, our conference. Also, planning is underway. It's going to be here in Nashville on the Vanderbilt campus this year. I'm not sure exactly about the dates. I want to say mid-October. I'll get those to your staff and we'll get those on your calendar for this year. And as the others have mentioned, a pretty good year for success, but you really have to watch our legislative friends all the time because there's no interest like special interest, and everybody does not have the interest that you have for public safety and planning, and I just encourage you to relationships that you have with the folks in the General Assembly. And thank you all for your time.
Thank you,
Nathan.
Good morning. I'm Don Baltimore, representing the Tennessee Interior Design Coalition, and my remarks will be very brief. We have been on the Hill again this year, and we are telling legislators we support the board and of AIA and the Engineers Association and Landscape Architects, and so far everything seems to have been successful. Let's keep our fingers crossed and hope it is for the rest of the session. So. I've enjoyed working with Candy, too. We've known each other a long, long time. Thank you.
Thank you, Don. That concludes the professional society reports. And with that, we'll move on to the legal case report by Anthony Glandorf. Finishes his email.
I do apologize. If there's an attorney out, I get to do that works for me. I get to do their job, and I get to do my job too. So I do apologize. The legal report was previously drafted. It was drafted by Ellery, so I'm going to present that to you all. I'll just give you a heads up that on the second one, I'd like to discuss that a little bit more. You all may as well also, because I may anticipate it changing our recommendation. But the first one that you have there is 201500.
Excuse me, what page?
Oh, I'm sorry, sir.
I think they're handouts, Jerry.
Oh.
Yeah.
If you're all ready, I'll go ahead. It's case number 201500102, and I'll just give you the brief explanation here. It appears that the respondent, who is a licensee, had at his employer's work send an email chain to the supervisor of a potential new hire for the firm that he worked at. And he told the supervisor, who was his friend, please do not let your person come and work for us. The company that I work with is the worst run outfit I've ever seen. The management team is inept, corrupt, and lying, and the company is about to fall apart. The complainant here states, who is the company, states that the respondent failed to update his address with the board as required. It seems like a secondary issue. The respondent did provide a response stating that, basically this supervisor was his friend, and he had honest concern for this new hire coming in and working with this company that he currently worked at, and that person's, beginning of their career right out of school. After looking at this with our analysis, we recommended to close this complaint, that there's not sufficient statement of facts here for any violation that we could see within the rules or statutes.
Second.
We have a motion and a second. Any discussion? All in favor signify by aye.
Aye.
Opposed? Aye. Thank you.
We'll move on to the second complaint now. That's number 2015000204. And what we have given you, we have really tried to briefly summarize a long history of discipline. This respondent is someone who seemed to be engaging in work and was licensed in Missouri also, and it began to start having problems with the Missouri board back in October of 2009. And I'll tell you the end result. As of December 2014, his license was revoked by the Missouri board, and currently it is revoked by the Missouri board. And now I'll go back and tell you how it all started. In October 2009, this licensee was placed on probation until what would have been October 2014. During his term on probation, he had a complaint against him for violating that probation. That was in March of 2013. In May of 2013, the board issued an order stating that he had violated his probation, and basically their order would have put him on probation until 2019. However, later that year, November 2013, the circuit court in that area reversed their May 2013 order because of sufficiency of a notice issue. And so later on, after that, pending all of that, what the court would have done is they remanded it back down to the Missouri board, and then the Missouri board in February of 2014 made a sufficient notice to him and revoked his license, putting him on a 5-year probation. So as of February 2014, he was on a 5-year probation. Well, there was another complaint for a violation of that probation that just recently occurred in October 2014. And there was a hearing in November of 2014 for that probation violation. In December of 2014, that there was an order that actually has revoked his license. It is revoked. There is no probation, no secondary chance or whatnot on his license. So those were the facts that we were attempting to convey to you. The recommendation that we have provided there to you, I will admit I currently don't agree with, because when we were discussing this recommendation, it was my assumption that his license was revoked with another probation, that currently he is on probation. Did not realize that that was a revocation without a probationary period. And so I would give it to the will of the board, but my understanding is that general recommendations for somebody whose license has been revoked in another state is to recommend the revocation of his license here in Tennessee. And that's a recommendation that I'll give you today.
I mean, I think that's our standard. If it's been revoked somewhere else, I mean, we don't want to inherit somebody else's problems. I think we've been consistent on that, if I remember correctly. John?
Revocation's pretty severe. We have a recommendation from legal. Can we get a motion?
I move that we revoke this operation.
Motion, can I get a second?
Second.
Second.
We have a motion and a second. Is there any further discussion? No discussion? All in favor signify by aye.
Aye.
All opposed, the same. The motion carries. Thank you.
Thank you, and that concludes the legal report.
legal report has concluded. Let me see here. Let me get on the next page here. That takes us to the director's report. John Cothran.
I got several things to report to you. First, on national council meetings, Rick Thompson, Frank Wagster, Jerry Headley, and I attended the NCARB Regional Summit in Long Beach last month, and there's a written report on that meeting in your meeting documents, and it's for your review. Also, Hal Bothrop, Ricky Bursai, Stephen King, and I are going to attend the NCAAS regional meeting in Scottsdale, Arizona on May 14th through the 16th. Robert Campbell and I delivered a presentation on qualifications-based selection and new board policies to the Knoxville branch of ASCE last month. And several administrative issues I want to bring to your attention. All of the grant funds for this fiscal year have been distributed to the schools, so they've all received their money. I've also confirmed that the UTC College of Engineering and Computer Science will host our meeting and planning session in October. And just a reminder, we did change the dates of that meeting in February to October 14th through the 16th. I think the calendar on your iPad still has the old date, the 7th through the 9th, but we moved it to the following week, so it'll be October 14th through the 16th at UT Chattanooga. Also, you already received an email about this, but just to remind you, Joyce Schrum did retire from her office on April 3rd. And Wanda Garner and Frances Smith have assumed her duties, which is primarily processing architecture, landscape architecture, and interior design applications. So Wanda and Frances will be your go-to people on those applications at present, which Wanda's enjoying, right? Yes. And we are going to present a resolution to you commending Joyce for her service at the June meeting, so something that we'll anticipate for our next meeting. Also, a new board website has been developed and is going to be unveiled this month, supposed to be unveiled this month. And the content is really unchanged. It just has a new look. It's reformatted, but the content's really the same. But they will be removing my picture from the website, I'm sad to say.
No beard or?
Yeah. Yeah, the picture was a little outdated anyways, yeah. I'm much younger looking in that picture with no beard, so that's going away. Our new licensing system, I've reported about this before, but it's been some time since I've given you an update. Our new licensing system, which is called CORE, is scheduled to go live in September of this year. There's been some delays along the way, but I think our information systems office is confident it'll be ready to go this year. And training for employees will begin soon. It's very similar to our current licensing system. It's just in a new platform. It's web based instead of being an outdated Unix system like that we're using currently. So it's really just in many ways, it's the same system. It's just a new format. So it should be fairly easy for everyone to pick up. Eventually, we're hoping next year that this will allow for online applications. So they're not going to have to send us a paper form with a check through the mail anymore. But that's possibly next year when they're going to release that version of it. Also, the next issue of the board's newsletter will hopefully be drafted very soon and sent out for review. I've been waiting because we wanted to include an announcement about our upcoming rule changes in that newsletter, and that's been delayed somewhat. I think we'll report on this later when we get to the proposed rule changes, but you voted on them at the last meeting, but we didn't include the economic impact statement and all that in that package that was presented in February, so we're re-presenting them at this meeting. So that'll be in our next newsletter as well. Also, just I don't know if this requires a vote or not because we're not changing the dates of the meeting. We're going to have to adjust our meeting schedule for August to accommodate the formal hearing that was originally scheduled for tomorrow. We were unable to find a meeting room for the hearing on Friday, August the 14th. So our plan is to hold all committee meetings and the board meeting on Wednesday, August the 12th, and then schedule the formal hearing for all day on Thursday, August 13th. And this is the same schedule that we followed back in 2013. You may remember where we would do the committee meetings in the morning, the board meeting in the afternoon. We're just reverting back to that old schedule. So we'll do all the committee board meetings on Wednesday, the hearing on Thursday. And then we're not going to meet on that Friday, the 14th. So is that acceptable to everyone? I don't think it requires a vote because we're not changing the dates. Yeah, I would anticipate 9, but it kind of depends on how many committees we have meeting that day, but hopefully 9. Right, for the whatever committee's meeting that morning, right. And then the board meeting probably at 1, I think is the way we did it back in 2013. So that's our plan. We had to do that again just to accommodate that formal hearing, so that'll be on the Thursday.
We'll have 2 nights to stay here, correct?
Yeah, I think that's correct, right, Wanda? For some, they'll be staying Tuesday night if they have to be there in the morning Wednesday, and then, yeah, everyone could stay over potentially Wednesday night, yeah.
Okay.
Okay, also on page 100 on your iPads, and that's following the pagination on the bottom of the pages there. Page 100, you have 2015 pending legislation, much of which has already been reported on. The administration bill that was proposed, Senate Bill 81, House Bill 71, has passed in the Senate. Soon, I anticipate will pass in the House. It's working its way through. And that's, again, the main change that's going to make for us is that's going to allow us to change our application process for the engineer interns, where they'll no longer have to apply with the board for authorization to sit for the test. They can simply go directly to NCWS, take the exam, apply with us after they pass the test to be certified. And that's the process being followed by the majority of states, where there's no longer this 2-step process to take the test. You just go straight to NCWS. After you pass it, you apply for certification. And there's some proposed rule changes, a couple of rule changes in the package that we're going to look at today to implement that, assuming that this law passes, bill passes rather. Also, this has already been mentioned, Senate Bill 95, House Bill 84, passed with an amendment excluding architectural and engineering services in the House, and I guess it's working its way through the Senate. Senate Bill 474, House Bill 787, that's the one about sprinkler systems for townhouses. As Ashley mentioned, that passed in the Senate with an amendment allowing local governments to adopt sprinkler requirements for townhouses, and it's been recommended for passage in the House. The one that the board opposed, Senate Bill 620, House Bill 628, that exempts local jurisdictions have an established codes department from audit of its records and transactions by the state fire marshal, and removes the provision of law stating that state building codes supersede all less stringent provisions of municipal ordinances. That's been deferred. The privilege tax bill, that's Senate Bill 556, House Bill 678. That's recommended for summer study in the Senate. So I don't know if there's much hope for that passing. Y'all think so? Yeah, not much hope because of the fiscal note attached to it, I'm sure, the decreased revenue that the state would see. And then the bill, Senate Bill 978, House Bill 823, that's been amended to raise the threshold from 25,000 to 50,000. Originally it was 100,000, so that was amended to 50,000. And there was one about the stripes on steps of public buildings. That's been deferred for study in the House, although it did pass in the Senate. And I won't mention those last two, but they're not going anywhere. But the last one I want to mention is the appropriations bill. They did include a provision in that bill that would earmark $350,000 for the board's grants program. Currently it has been set at $300,000. So they did include an increase in the bill to raise that to $350,000, which hopefully will be in the final version that passes. So that's certainly a good thing. You do have some complaint reports beginning on page 102 on your iPads. Page 102 is just a snapshot of open complaints as of the 30th of March. See, our numbers look good. Our percent on time in the last 18 months is 99%, so we're doing good on those measures. Although you will notice we only had 10 open, I think right now we have 11 open complaints. Last time I counted, actually I think it's more than that now, but Francis opened some yesterday. So, but still a very small number of complaints, smaller than we've seen traditionally. And I'm sure there's many reasons for that, but certainly if you're aware of violations, let us know, because we would like to see more. Then you do have some statistics, complaints for fiscal year 15 versus 14. That just shows you civil penalties assessed, collected, complaints open, closed, followed by some statistical reports, basically showing that only a tiny percentage of our registrants are subjected to discipline or have complaints filed against them. And unless you have questions, that's the end of my director's report.
Questions? None being, we'll move on to the engineering committee report. Al, could you speak into the microphone, please? Thank you. It's all right.
The engineering committee did meet yesterday, and we covered a variety of topics. We reviewed one application and made the necessary approval. I'm going to let some of my colleagues cover some of the content of what we covered yesterday, but John, do you want to cover the aerial adventure courses issue? What we decided? Are you going to present to the board later? Are we going to?
It is on the agenda later,
Okay, then we'll
but you
talk
could
about it
report on
later.
what the
Thank you.
engineers.
We'll talk about it later.
We can talk, if that's all right, we'll just talk about it when we get to that part of it.
We're presenting ceiling subsurface utility engineering survey documents was discussed. That issue in our observation and determination is an issue for the surveying board. So John is going to defer that topic to the surveying board in the coming days. We did have a conference call with a licensee on a question concerning some clarification of a request that was being made of this licensee by a jurisdiction that included and involved his seal. And after conversation, we had made a determination that onto the registrant with some definition and direction from the board as it relates to the proper application of the seal. Also copied in that correspondence, because the registrant had copied a local codes authority person from his clients or from the jurisdiction that made the inquiry about using his seal, and copied several others. The response letter from the executive board will include copies to those individuals as well. And then if the issue generally has to do with systems and prefab structures and foundations, and what is required in terms of sealing such components in the state of Tennessee. So there might be more discussion about this moving forward. Do any of the committee members want to add anything to that? Okay. Ricky, do you mind covering the standard of care fire sprinkler design issue, please?
Sure. On page 71 of your iPads is the policy statement for sprinkler shop drawings. It's in our handbook, and we added a paragraph to that as a result of the last fall retreat when the Sprinkler Contractor Association attended our meeting and brought up a problem that they were seeing. And that added paragraph appears on page 71, and then in the following page, that led to some other general cleanup of this policy. it looked more like a policy of the state fire marshal when it's really a policy of this AE board. So that, there's some cleanup marks there, and that policy right now is being reviewed by ACEC as well as the state fire marshal's office. Those are the two.
Contractors Association.
Okay.
Yeah.
So we're waiting to hear all the comments from that, and we've gotten a couple of good comments from that review, and so that's in progress but almost finished.
Thank you. And then we again discussed the decoupling of experience, an exam requirement for PE registration. We did receive from Ms. Toller yesterday position statements from both the Tennessee Society of Professional Engineers State Board and the ACEC of Tennessee State Board. Current status of position, TSPE is in favor of the decoupling. ACEC is currently not in favor, but are open to more discussion and determination as it relates to the issue. So as a committee yesterday, we discussed what to do to move forward. Part of it included continued interface with the TSPE State Board and the ACEC State Board. And so through John, we may ask to be put on the agenda for their next board meetings, further the conversation. The issue will be discussed as well. We're certain at the joint Southern Zone, Western Zone meeting that John mentioned earlier that's going to occur in May. Certain that it will be continued to be discussed at the national conference, NCAAS National Conference in August. Currently there are 9, John, or 10 states.
I don't know the exact number.
9 or 10 that allow or have decoupled the exam requirements from the other criteria used for eligibility. So most close to us that you may be aware is Kentucky and South Carolina. Our legal counsel, including Ellery, refreshing and substantiating what Rob had already advised, that a Kentucky, for instance, candidate or Kentucky registrant, once they got their license in Kentucky, could apply for comity in Tennessee and subsequently likely be approved. A state eligible candidate for licensure currently still has to wait 4 years after the qualifying degree to gain the experience in the minimal 4 years of the references and everything to be eligible. So the conversation is dealing with an equitability issue with in-state registrants or potential registrants and those that might come to our state through the comity process. Solar. Okay.
You said that somebody Kentucky requesting comity could be licensed before having 4 years of experience? Okay. So it's the 4 years of experience is still going to be required in
Correct.
Tennessee no matter what Kentucky did about theirs or South Carolina.
Correct.
Okay.
Sorry, didn't mean to confuse the issue. It's the order in which they secure their credentials.
Okay.
That is the issue.
It's still the credential though.
It's still the credential, yes, ma'am.
Let me add just one quick thing because of these letters that we got last night. I don't think we had real quick. But we have received correspondence from ASCE, from TSPE, and ACEC. And all three have the exact same, more or less, wording in their document that says something's wrong with the test, okay? I would like to hear from the respective organizations, what they believe would be ways to fix that test, would be satisfactory progressive experience, or excuse me, satisfactory testing that needs to happen so that we can take this to the powers that be in our Southern Zone meetings and our national meetings with specific recommendations. And I'm not saying I disagree with them, but I would like to hear their perspective on what those things we need to do to make the test more robust, and so that we would have, it's not, as they put it, and we have said before, an academic exercise. I just would like to hear from the collective wisdom of those groups on what those need to happen, right? Okay.
And for those of you not familiar, to add to Robert's comment, the issue has become, the PE exam has become more academic and less of a practice exam as it was originally instituted. So I agree with Robert. I think it would be interesting and helpful to solicit feedback on what would constitute the type of exam that the societies believe is in the best interest of licensure. NCAAS, on that point, often solicits engineers to participate in the development of the exam, usually by discipline for the specific exam, because there are, I think, about 17 professional engineering exams by discipline that are currently offered, which is a lot. And I know that they were looking for civils, particularly in recent years, to participate in that. Might get more information about how engineers could participate in the development of the exam with NCAAS and be able to report that too if and when we get to meet with the boards, maybe this summer. When is the next scheduled meeting? By
Oh, no, it's ACEC. ACEC is in Chattanooga.
Okay.
TSPE is out of state.
Montgomeryville.
TS.
I'll send them to you.
Yes, or send them to John if you don't mind.
Both retreats too, so we can build some time in.
Okay, that'd be great. And then, well, and you can send them, if you've projected out, I know the annual meeting, but if there's another meeting during the summer, if we can't make the May meeting, so that'd be great. Okay, engineers, are there any other items you want to bring before the board today? No?
Thank you, Hal. The next item is the Joint Landscape Architect Committee report. And I would like to defer to Bill, since our discussion this morning was pretty much landscape and nothing else. So, Bill?
I think we looked at the exam, or the request for the exam, early exam, and we were okay with that. And I think that was also the architect's decision that those applications were acceptable to us.
Any comments from you guys regarding it?
Just
okay.
what Bill said.
That's what Bill said. Very good.
Thank you.
Short report. Thank you. The next item is the Publications Committee report by Stephen.
Publications Committee met in February. We made some assignments for some revisions, and we're going to review those this afternoon. Hopefully, we're moving toward finalizing that.
Thank you, Steve. Next on the list is unfinished business. Mr. Cothran?
We have action items on page 108 on your iPads from the February meeting. Of course, we did schedule a nominations committee meeting this morning. It appears later on the agenda. The reference manual is in the process of being reviewed and revised, so everyone's working on their assignments there. The engineer committee did, as reported, meet with Mr. Tomasello by phone, and is working on the sprinkler shop drawings review policy. We are in the process of filing proposed rules, of course. Those are on the agenda today. Ellery has worked on our QBS FAQs, so that's also appears later on the agenda for discussion. Susan was going to communicate regarding the state fee schedule with AIA.
Yeah, the one person I was waiting for a letter from her had a death in her family, so it'll be shortcoming, I hope. And then we have that the AIA has brought up with the state architect, and so we want to be supportive of them and give them some of our information to help back up what they are hoping will occur in the state contracts. So we're moving forward.
And of course, landscape architect committees met this morning to discuss the new applications. For board discussion, we had an item from a case that was presented at February's meeting. Consider whether the board has the authority to discipline the owner in a case where the owner basically put the title PE on some plans that were prepared by someone who's not registered. And the board wanted legal counsel to consider whether the owner could be subject to discipline for doing that, for placing that title on those plans without the preparer's knowledge. And I talked to Ellery about this, and it's her opinion that the board would not have authority in a case where it's simply a matter of putting a title on plan. She didn't feel that really would be much of a case. Essentially, we have to think ahead as to how much evidence we would have if it goes to a formal hearing and things of that nature, and she didn't feel that the board would really have authority to discipline the owner in a case like that. And I don't know if she talked to Tony about it or not, but no, okay. That was
I
her
apologize,
opinion.
it's a new issue for me, though. If you would like me to look at it and come back to you, I'll do that, but I would need more time than to give an opinion right now.
But do you want us to further consider that issue, or? Okay.
Is that, I'm a little confused. Is that not practicing engineering without a license?
Well, all he did was just place the title. In this case, he just placed the title on the drawings.
I would assume that it's
PE
forgery, in my opinion, that he forged the
Yeah.
information. And Tony, as a board member, I would like for you to look at it, because this may come up again. And we may not have any jurisdiction, but it'd be nice to have a clear line in the sand.
I can do that. Could you all please make a motion and make a clear statement as to what you would like me to review so that I can write it down here, make sure that I do actually review the exact thing that you want me to look at. I'd appreciate it. Would help me out.
I move that we have legal counsel further review case number L14-AEL-RBS-2014-02-6091 in regards to a non-registrant putting professional PE by another preparer's name to indicate that that individual, that preparer, is a professional engineer, and see what recourse the board may have, because that is falsifying a legal document.
Is it your opinion that it was falsifying, or is that the question?
When the owner put PE by the preparer's name without the preparer's knowledge, he's falsifying a document. And as to whether or not the board can pursue legal action against the owner in this case, and what other options there may be to prevent something like this from happening in the future. We on this board who are all licensed, if we were to do something like that, our license would be gone in a heartbeat. There would be no question. But since the owner is not licensed by the board, but he did something that indicates that another individual is a professional engineer, that's falsifying a document.
Steve?
I was assigned that case and investigated and reviewed the file for last month, and that owner did admit that he did that. I think that's really what you were asking. And it's in the file that John can provide.
I'll look at that and I'll let you all know. Thank you.
Vicki?
And just one more aspect of that we feel like someone who projects another person as a registered professional as a health, safety, welfare threat. And if it's not in the purview of this board, what board is it? Who would have authority for that?
Mr. Glandoff, did you hear what Ricky was?
And like if it's not us, then who is the disciplining
Yeah,
authority?
it's definitely health, safety, welfare. If you represent yourself as a surgeon and walk in an operating room, or somebody else as a surgeon, we look at this as the same way. It's a health, safety, welfare.
I agree, it would be this board that would be the disciplining authority. I think the question to determine is whether or not this set of facts actually would fit into a statutory rule violation and the interpretation of that. I think that's basically what it is. And I apologize, we don't have something written up for you more formal, but this is the first time I'm seeing this, and before spouting out an answer to you all, that I'd rather just at least look what the documentation is so that I'm a little bit familiar with the facts before I state an opinion.
I think that's a good idea. Do we need a motion on that, John?
I think a motion
Oh, we
was
got a
made, but it
motion. Oh, you
hasn't been
made the
voted
motion,
on.
I'm sorry.
I'll second that motion.
We have a motion and a second. Any further discussion? Not having any, all in favor signify by aye.
Aye.
Opposed, the same. The motion carries. Thank you.
Yeah, I think that's pretty much it for the action items. I know Susan was still going to write an article on the interior design profession. That's long range, and the other goals are either completed or in process. So that's it for action items. And we do have some proposed rule changes to present as well.
Well, I have the paper printed out copies of the
Everybody got three
proposed
copies?
rules, and there should be three different things that you're looking at. I'd like to start off by presenting to you all the one that is entitled Emergency Rule Filing Form on the, if you look at that one. And I'll explain what this is. Some months ago, you all previously had a rulemaking hearing, where at that rulemaking hearing, you all wanted to change the application fee of, who is it? Is it? Engineer interns, thank you, the engineer interns from $50 to $15 at your rulemaking hearing. And that document was filed at the Secretary of State's office, and that document, the way it was filed, had we'll just call it a typo. There was a sentence that was deleted from the beginning of the document, which basically referenced the fee to go from $50 to $15. So you actually said that there was a fee to be charged to the applicant registrants, but what's currently filed, if it became effective, would not state what the fee is. So you would have basically kind of a quagmire of not really having a fee. So currently the $50 fee is in place. This issue arose just, I guess shortly after the first year, roughly, somewhere around there. And we took action. We were working with the Secretary of State's office under the statutory provisions. It appears that they have the ability to correct typos. And one of the supporting documents we sent to the Secretary of State's office, the red line would show that it was a typo. However, the Secretary of State's office didn't feel that this was a typographical error, and that they said that our only remedy would be to withdraw the rules. Withdrawing of the rules would undo everything we've done on this entire set of rules. We would go back to square one on having to file a new notice for a rulemaking hearing and whatnot. Needless to say, I've been very aggravated over this for the last few months, because I cannot believe that anywhere that the Tennessee law would not allow you to correct a known typo that everybody else would have known, that everybody kind of agreed that it kind of should have been a typo. But Secretary of State's office said, regardless, this is how we interpret the law is. So we had our really only option to stop the train and not stop everything that we had done was to stay those rules. So that's what I did. We filed a stay of those rules, which would basically put the effectiveness on the rules on hold for 90 days. We did that while the Secretary of State's office was determining whether or not they would think that this was a typographical error. And they came back recently and said, no, we don't believe that this is a typo that we can change up there just by changing the form. And so, so we have to go into a different way of changing it. So the emergency rule filing form here that you have in front of you is going to be our plan to remedy that, which is the emergency rule filing form will give us, once we file it, a reason to file an emergency rule. One of those reasons is to delay the effectiveness of a current pending rule. And that's what it is. All of our rules are currently pending that are at the Secretary of State's office, and their effectiveness would kick in May 1. So we have until May 1. This would give us another 6 months. We don't need 6 months, really. What we do not need. I'll have a second document, which is another proposed rule, which would actually create the fix without having to have a rulemaking hearing. So this emergency file is going to create a new rule, and the new rule will basically say that it is staying the rules that were filed on November 18, 2014 for up to 180 days, and that 180 days is by statute anyways. So this is a new rule that would be on place on the books that would stay the effectiveness of the set of rules that are up there right now. And I'm going to go ahead and transition into the proposed rule filing form, the larger one, and show you what this will do, which is the proposed rule, the larger packet of forms. If yours are in color, they are. If you turn onto the first page, what you'll see is you'll see in blue what we have added to the set of rules that you all have been looking at, or that you all have been kind of going over for the past several months. And if you look at it there in blue, this proposed rule would be one that we would file after filing the emergency rule with your all's permission. We would file this proposed rule, which would create the fix. It's going to make it so that the fee actually turns into the $15 fee as you all would have, or what you all would have requested, and it's going to make that fix along with all of the other rule changes that you all would have made. And this would become effective prior to the emergency rule terminating. And within that set of rules, it basically does two things. The proposed rule would, one, terminate the emergency rule. So we are terminating the emergency rule, and on the same day we terminate the emergency rule, we put in place the $15. I apologize for the complication of that. I know it is complicated. Myself and my boss have had to sit down late at night thinking about exactly how would the sequence of events work out. Because what we were trying to avoid is all of those rules up there would basically, we would have to withdraw all, we'd withdraw all the rules, and all the rules would be withdrawn. We'd have to do a new rule-making hearings or whatnot, or we would have to live with the fact that we wouldn't have a fee for engineer interns for a period of time until we had a new proposed rule in place.
This also, the new changes are implementing the system that I discussed earlier, where engineer interns could just apply directly to NCEES, and then they would only apply with us after they've passed the exam. The first rule, applications engineer intern, Rule 012001.06, it's going to read now that an applicant who has passed the required exam and has met the other legal requirements shall receive a certificate. So it's assuming that they've already passed it when they apply with us for certification. So that's one of the significant changes that we're making to in light of the law change that's coming down the pike.
And as part of the emergency rule filing that we have, we're required to receive this board's statements as to impact on local governments, along with additional information that's required by the Joint Government Operations Committee. And if you all see on those pages, we have put in basically our legal has placed in there basically a suggested response for you all in that emergency filing, which is basically a brief summary of what we're doing. We don't appear that this would have any impact on local governments for this which has to do with the fee, of creating the $15 fee, or staying the rule so that we can create it. And what I would need on each of these is, starting with emergency rule filing form, and you all are free to discuss and ask more questions, obviously, is that we would have to do a roll call vote on each of these filings, is what it requires.
Mr. Chairman, I move that we approve the emergency rule filing form as submitted to us by our legal
Motion.
counsel.
Second.
We have a second. Any conversation or additional comments? I have a question for Wanda. Do we roll call vote on this? Because of looking at all three of these forms, and it appears we do.
Wanda can read out the names.
And well, which one are we gonna do first? Because there's three signature pages.
Emergency rules.
Okay. Oh, just that one? Okay. Oh, I'm sorry. You had a comment?
I just got a quick question. Assuming this passes, when do these rules become effective?
The emergency rule?
Yes, and then the the proposed rule.
Emergency rule, my plan is to have the emergency rule, I want it filed no later than the week prior to May 1st, and it will be effective upon filing. So upon filing this emergency rule, these rules that you had the rulemaking hearing back in the fall would be stayed for a further 180 days. And then the proposed rule, since you all were basically going to authorize, if you all authorize this, the proposed rule would be filed in sequence close to the emergency rule. However, let's just say we do them on the same day, right? Best case scenario. The proposed rules have to be there for 90 days before they become effective.
We're looking at fall.
May plus, yes, you're
August,
looking at
September.
late summer, this summer.
Okay.
You're looking at three months from May 1st. So you have to May, June, and July. So you have,
September 1st.
August, roughly. Would be when they would all be effective.
Any other comments? No. Wanda, would you call the roll, please?
Ballard,
Here. Yes, sorry.
Al Balthrop. Wilson Borden. Robert Campbell.
Aye.
Jerome Headley.
Yay.
Philip Lim.
It's A-I-O-U?
Yeah.
Bill Lockwood.
Yes, aye.
Rick Thompson.
Aye.
Frank Wagster.
Aye. A-I-O-U?
Ayes, nays have it.
Ayes carry.
Yes, so no motion for the proposed, and also I'd like for you all to point out, we have, the proposed what it's in blue, our idea is that if we put it in blue, it's what we've changed since last meeting, because I know there are a lot of changes here. We really don't want to confuse you all. I do apologize for having to bring so much. And so, we would, yes, need to have a roll call vote also on these proposed rules, but I would like to point out to you all, on page 16 of those rules, there are the regulatory flexibility addendum. And I believe you all have already looked at this, and we have given our model responses at that. But I would just like for you all to take a look at that so that when you make your roll call vote, you are doing that, having seen our regulatory flexibility addendum, and that you do agree with that. And this is basically has to do with the impact on small businesses here in Tennessee.
I make a motion that we approve the proposed rule filing form in its entirety, including the regulatory flexibility addendum.
Second.
Motion and a second. Further discussion?
On page 10, the reference requirements were being updated for educators, Tony. It is not in blue. It is underlined. Are we okay because we changed it for the architects as well, that the 5 references do not have to include a client because educators typically don't have clients.
That was presented in February,
Okay.
so it's.
So we're okay?
It's something you've seen before at the
Yes.
February meeting.
Yep,
That's why it's
okay.
not in blues.
Okay,
We're only concerned about the blue.
because the blue is new.
The blue is the new.
Since February, yeah.
The blue is the new since February. What you would be voting on is the entire package. You've already voted on the previous edits within the package, but this actually would certify the entire thing. So if we need to take more time to relook at these things, I'm absolutely amenable to doing that. I want to make sure that you all are making your votes on, understanding the impact that we're taking all of these. And if you look throughout the document, it's the red line version, so it's underlined or things that we're adding, things that are crossed out or things that we're taking out. So yes, that's why it's not in blue.
Thank you. Any additional comments?
Question, Mr. Chairman.
Yes.
On page 2, we have just approved the emergency filing for that so-called error that we make on that $50 to $15. So I guess just a point of clarification, when this filing rules is not in conflict with what we just did earlier, the $15 emergency filing in terms of timing?
So what will happen is that no, these are not going to be in conflict of that. What you're doing is you're authorizing the emergency filing, and once the emergency filing is filed, that will stay the current rules that are in place. This set of rules, once they are filed 90 days after becoming effective, they're going to do 2 things. One is it's going to terminate the emergency filing, and then at the same time, it's going to kick in the effective rules. Those current rules that are pending up there will currently be effective. And basically, you'll have no fee, and then on top of that, we're going to place the $15 fee.
Thank you for the clarification. Thank you, sir.
Thank you. Any additional comments before we vote? None? Wanda, would you please call the roll?
Ballard.
Yes.
Hal Balthrop. Wilson Borden. Robert Campbell.
Aye.
Jerome Headley.
Yes.
Philip Lim.
Yes.
Bill Lockwood.
Yes.
Rick Thompson.
Aye.
Frank Wagster.
Aye.
Motion carries. Thank you.
There's one more. The third rule document that you have is another one that is captioned as a proposed rule, and this one is regarding a military applicant rule. And I believe that you all had authorized the previous version of the language in the past, and that language, when we sent it up throughout the department, was rejected based on an insufficiency of compliance with the statutory requirement, meaning that the provisions of the previous rule were not did not broadly encompass the requirements that the statute contemplated on providing a temporary permit for military applicants. The document that you have in front of you is again, it says proposed rule. And what it does here is it creates a new rule, and I'll go through that with you. The new rule is that we put in here has model language that we're using throughout all of the boards and commissions. And just so you know, this rule is not just required for this board. Under the statute that was passed, all boards and commissions within our department must create a rule because the statute exists. And the statute says that people who are military applicants, well, I'll tell you what the gist of it is what the legislature intended to do was that for certain military members, and more specifically military spouses that moved to Tennessee, i.e., for example, moved to Fort Campbell, who were previously licensed in another state where there is may not be reciprocity in the state of Tennessee, and they have similar but not exact standards of getting licensed in another state, that there is a mechanism that they can go ahead and be temporarily licensed pending completion of all education requirements in the state of Tennessee. I don't believe it came up because of this board. I believe it came up on a different board and different type of educational system. And what they were finding is that there were military spouses who came in and said, I did not have a choice to move. I had to move because my husband received, or and I assumed that it was his wife, or my wife received orders to move here from New York down to Fort Campbell. And I tried to get licensure in their state, and you all said, hey, you know, you're going to have to take 600 more hours of education to get licensed here in Tennessee. And so there was an economic hardship that were put on those families. And I believe what the legislature wanted to recognize is that that person was, they basically, that they had a hardship that was really undue, and they wanted to give them a temporary provision to go ahead and practice in the pendency of receiving full certification. So that's the gist of what the rule does. It says, you know, upon application, there will be a temporary permit to issuance for them to go ahead and practice in the state, so long as they're meeting and moving towards the requirements of full licensure within the state. I have never seen this rule actually used yet in the 2 years that we've had them with other boards and commissions. So for whatever reason it came up, it must have been a very rare occurrence. There's a second part to this also, which has to do with certain military members. So military members who are close to retirement, roughly 180 days from actually retiring out of the military, and they're going to move to another state. The statute allows that they can basically come in and they can very similarly do what the spouses did, which is they can come in and obtain licensure so that they can practice in the interim after retirement until they receive full credentials within the state.
Robert, you had a comment.
Yeah, one or two things, Mr. Chairman. Anthony, we've already approved this. Is that correct? We just didn't approve the addendum?
Yes, that's my understanding. That you all did approve it last time, but I think you all had to approve the regulatory flexibility addendum, and I apologize if I'm reiterating something, but when you all vote, you're going to vote on the whole thing. And I want to make sure when I certify this that everybody, I don't know who was in attendance last month. I apologize. I should have probably started out with the caveat of that.
What you just said, from an engineering perspective, the only thing in my mind that's got me, and you use the word New York, so that kind of tweaked me a little bit. New York accepts engineering technology degrees. We don't. So I reckon I'm having buyer's remorse, but I wonder what does this then lock us, because basically you're saying that somebody with an engineering technology degree could come in and do professional licensure up until they may have to go to school for 3 or 4 more years to get all the coursework they would have to get a ABET accredited engineering degree. For accepting that, does that not, I think that weakens what we've tried to do, and I think that also potentially gets the camel's nose under the tent a little bit when it comes to technology degrees, that we've had a pretty robust effort to keep that from happening in the state of Tennessee. So again, what you just said, and you said the keywords New York, I reckon something finally clicked. This brain moves, but it moves fairly slow. How that's going to work for us. Thank you.
Bring up a good point, and what I've been had to explain to other boards and commissions is that this is not it does not contemplate every scenario. The statute doesn't, and the rule doesn't. So the language in there is flexible, wherein it contemplates. If you look at 1A, it's basically saying the board may. It's discretion to the board, so that if you all see that the licensure is substantially equivalent, you may go ahead and issue that licensure, or you may issue licensure to permit people where you do not see, where it basically in B it says does not meet the requirements for substantial equivalency, but the applicant could perform additional acts, including but not limited to education, training, or experience. And the board may issue upon application payment all fees required for issuance. Now, there is discussions to be had in the future where if another state has almost polar end opposite requirements that we have here, then that may not be the type of scenario where this temporary permit is actually going to apply. Does that make sense? There's
Well,
discretion upon the board, and there should be a discussion as to what those are.
Right,
Those
and I-
educational requirements.
Yes, but it does compel us to provide a temporary permit in the interim, while they are working, because somebody could come into the state of Tennessee, and again, I'm sympathetic to the cause behind this, but they could come in the state of Tennessee, they could say, we're gonna start working towards the requirements we need, give us a license, and then for the next 2 years, 3 years, or whatever that temporary permit is, they could be sealing and signing engineering documents
Right.
that potentially could put the public health, safety, and welfare at risk because of not sufficient background. And I don't know if the architects have a similar thing, but that bothers me a little bit.
I think I can answer the question with this, is that the statute doesn't require you to issue a temporary permit to all of these. The statute requires you to create a rule that discretionarily says that you may issue the permit. So now you have a procedure and process in your rules that you may issue this type of temporary permit, if that makes sense. So you would not be required to issue them on every case basis that comes before you. It's in the discretion of the board to make that determination.
Yes.
Philip?
Tony, I agree with what the discretion that we have as a board to even decide. We have to still do the due diligence and make sure that they meet our three-legged stool, which is the education, training, and examination. On page 2, point number 2, actually, it clearly said military education training experience shall completed by a person described per TCA so-and-so shall be accepted to as a qualification in whole or part. The word shall, to me, implies that we don't really have any option if somebody, but can I also argue the other way, saying that you don't meet that TCA section that mentioned here, I can deny your application? Can I do that?
Under 2?
Yeah.
Well, if you keep reading, I believe yes, under 2, it says, shall be accepted towards qualifications, whole or part receive any certificate issued by the board if such military education, training, or experience is determined by the board to be substantially equivalent. So it says you shall if it is deemed to be substantially equivalent. So if somebody comes forward and says, hey, I have military education training as an architect, and it was just saying, I'm an architect as engineer, and they provide that to you all, and they say this is substantially equivalent, and you all say, no, it's not, then you're not required to give one. You just have to make the determination. You at least have to give them the opportunity to come and put on their case. And if it's not substantially equivalent, in your opinion, you do not have to issue that.
Thank you, thank
Yes.
you. I just want to make sure that we're not showing given preferential treatment, and yet at the same time not to be relaxed about our rules in the sense that we still have to do due diligence and go through the application process. Thank you.
And one other comment, under item 1 on that page, it says we may. So,
Yes.
I mean, that's.
Absolutely.
Right.
It's all discretionary.
It's all discretionary.
The issuance is discretionary towards the board. What is required that you have a rule, a process, so that you may discretionarily give or not give.
Okay, thank you for
Yes.
clarifying that.
Do we have a motion?
No, I don't think so yet.
Move that we approve the proposed rule filing presented to us.
A second.
Do we need to give a rule number or anything?
No.
We have a motion and a second. Is there any further discussion? None being, Wanda, would you do the roll call, please?
Ballard.
Aye.
Hal Balthrop. Wilson Borden. Robert Campbell.
Aye.
Jerome Headley.
Aye.
Philip Lim.
Good, yes.
Bill Lockwood.
Aye.
Rick Thompson.
A.
Frank Wagster.
Aye.
It's unanimous.
Thank you. That completes the items of rulemaking that I need to provide to you.
Motion carries. Thank you. Yes.
Counselor, before you leave, I have a curiosity question about this. If the Secretary of State does not or did not believe that this was a typo error, did they happen to say what they did believe was the problem?
That's the thing about working with other departments, especially if they're constitutionally separate, is they really don't answer to anyone.
I thought,
But
thank you.
no, but I know this is being recorded. I'm not trying to say any disparaging remarks against the Secretary of State's office. They're very helpful with us at times. They do. No, we really did try to work with them, and they did work with us. And to be on all honesty, they did kind of. We actually. Our department and their department went back to the Attorney General's office, to those attorneys who represent us both, and they both talked about it and whatnot. And my understanding is that it went up to the Secretary of State's office for the discretional determination as to whether or not we want to do this. And they stated no, that we don't want to consider this to be a typographical error. They'd rather it be a comma, a period, a capitalized letter, something of that nature. Because these rules are actually certified by you all here, they were certified by our office. They went to the Attorney General's office, and everybody, I can't tell you how many pairs of eyes looked at all of these rules. And it wasn't until after it was filed, someone said, I think there's a sentence missing, but it was a large package of rules. So it's been a learning curve in our department. We've had to have, a third set of eyes of nobody who knows the rules to go through these things page by page by page to make sure that we haven't left out a sentence. And it's an embarrassing happenstance, but I appreciate your comments there. Thank you.
Any other questions? I do have a procedural question for you. On the signature sheets, it says if required for the votes. I don't think that's not necessary as long as I'm signing them.
No, sir, it's not required. I can
Okay.
actually, the name of the officer, I can actually sign on behalf of everyone there.
Okay.
As the
But I
attorney.
still have to fill out my portion, right?
Where it says the signature, name of officer, sir, title of officer.
Yeah.
No, I can do that.
Oh, it's-
Generally,
okay.
yes, the attorneys
Okay,
do
good.
it. Is
I
that
don't have
we'll
to
do
do
it on your behalf. That's
Thank
why
you.
we received your authorization. We'll do that.
All right, good. Thank you very much. All right. I guess qualification-based selection is next. We're finished with that.
Would everyone like a break before we move into that, or?
I think we would.
Yes, I thought you might.
Thank you.
Motion to adjourn for 10 minutes, Mr. Chairman.
Motion and a second. All in favor? Aye. Or A?
A-E-I-O-U.
I know.
I need to pull the book, the Robert Rules for y'all to listen.
Oh, we follow that? I don't know. We're supposed to.
Apparently.
How that prepared we voted to approve in the case.
Hey, Wilson.
Called back to order. Let's see, where were we? The qualifications-based selection conversation is next. Is that correct,
Okay.
Joe?
Yeah, I can start that off. It's on page 111. You have some proposed revisions to the frequently asked questions about qualifications-based selection for public projects. Page 111 on your iPads. As you may recall, in January, Ellery Tony and I met with an attorney in the AG's office to discuss the board's interpretation of the QBS law, some of our FAQs, and we got some feedback from the AG's office on several of our interpretations. And one thing we found out in those discussions was that there's a different statute that establishes the procurement procedure for public schools that's separate from the QBS statute, TCA 124107. So they advised us that the QBS law really doesn't apply to public school systems since the law allows them to procure architectural engineering services competitively. And specific trumps general, basically, is the principle that they're using there. So in light of that, question 1, to what projects does TCA 124107A apply? We just added a sentence that there may be an exception for certain public school projects, and then it refers them to FAQ number 4, which if you go to that question, it's regarding whether the law applies to public school systems and public building authorities, and rather than just answering yes, we just cite the jurisdictions to which the QBS law applies, and then we added a section, however, TCA section 492203A3C, which prescribes the specific procedures to be utilized by school systems in contracts for professional services, allows public school systems to utilize competitive bidding for the construction of school buildings or additions to existing buildings. Construction would include construction-related services, including design. This exception does not apply to contracts for energy-related services that include engineering services pursuant to a different section of that statute. So a little more complicated than just saying yes, like we originally did.
John, I have a question on that, and maybe this is a legal counsel question, but would the way, if you were going to try to resolve that to where the schools were under the QBS process, would just defining construction as somehow not including design be a way to do that, or rewrite that particular requirement there? It seems like the interpretation of construction that's said here includes design, which, construction to me indicates building of the building, not the design of the building. But
yeah, and that's kind of what I thought as well, but Ellery and I looked through several AG opinions on the issue, and the AG seems to consistently interpret construction more broadly to include design as well.
I guess what the issue being is that it could be interpreted that way. I mean, that's we don't have the final say on it. Like over here in legal, that's not our statute, someone else's statute. It's just what is the potential impact of it? It could be. And so the Attorney General's opinion, the Attorney General's office they didn't make a formal opinion on that one, but they said it looked like they potentially would lean that way if given that opinion. So they just kind of, when we talked about it, I thought it was very odd also. I can tell you this, that I've spoken it with my boss, and the way that we think we should look at it is very, if we're going to give people official advice, is to really look at it as the words are written in the statute, which is construction. It doesn't necessarily say design, and wait for somebody else to make that determination. What does that possibly be? I mean, I guess the worst case scenario is there's someone out there gets sued who's a licensee, and then they turn around and say, well, why didn't we tell them something about it? Well, it's not our statute to interpret. I mean, the court would say, thanks for your opinion, but I don't know. But this isn't really something that you all regulate, because it's not our statute specifically.
But we'll have to make the call if a complaint is filed against, say, an architect for submitting a competitive bid for a public school project. That's when the board comes into play here, where they have to determine, is that a violation of our rule that's based on the law or not in cases like that?
Well, yeah, and I think that complaint would come in, it should come in parallel to a complaint against the municipality for actually accepting a bid that was in violation of that statute.
We don't have jurisdiction against municipalities.
No, we wouldn't, and
It's
we
our
wouldn't be
registrants.
looking at the municipality. The question would be who is going to go back, whether or not the municipality is going to be told, you should not have taken that selection. It's kind of the way. Wouldn't it be odd if we said, you're okay, and then somebody on the municipality said the municipality was in violation, right? I mean, that's the problem there. Is it's possible we only regulate the architect. I mean, we regulate the architect and engineer around here, and you all would have a rule saying that if you violate QBS, that would be a violation on this part, and that could be determined here. Well, what if, and the other statute says a municipality cannot make a selection based on QBS. What if we said here, you are in violation, and then there was a complaint on the municipality, and whoever makes that decision said the opposite? Well, you all would not be happy with that, obviously, right? I mean, wouldn't consistency be one of the better things? So, yeah, I agree. It puts it creates an odd situation and scenario. Did I lose anybody on that?
Well, and one comment about that.
I guess I'm sorry.
One comment about that, the people that are affected by this are generally the state And then and a large portion of the non-state projects are local school projects that put out RFPs like this. The state already tells you what you get paid, and they do base their selection on qualifications. So it really, the QBS law that we have, if you take the K-12 schools out of it, then you've pretty much eliminated, I mean, there are private colleges and things like that, but pretty much taken the legs out of it, in my opinion.
Robert?
So it's fair to say that our definition, oh, I'm sorry, Laura. You're up first.
I have a point of clarification. Public schools, is that K through 12, or does that include the the universities as well?
Public schools, I couldn't
So,
give you any more
so
clarification
this
than what it
QBS
says.
is written on our understanding that this could involve all of K through 12 and TBR and the UT system, all public schools. And it's focused on the word construction being interpreted as including design. Is that correct?
That it could be interpreted as
I think
including
those are
design.
important conversations, both of those.
Right.
And not, I don't know that we should be, in my opinion, putting a QBS statement out there that hinges on things that we don't understand fully.
I think that some of the licensees are coming to us saying, would I be in violation of this QBS statute? Well, the statute that is regarding the QBS and municipalities isn't looking at the engineers and architects. It's looking at the municipalities, the people who are supposed to be taking these bids, and it says they should not be selecting bids on anything other than quality-based selections. So when they give out the bids, they should be asking, provide your quality, provide your credentials and things of that nature. So the violation is on the municipality. What we've had is our licensees coming and say, how do we keep from being in violation of this?
Because our statute, our rules.
Right, our rule says-
now say that's based on that statute,
Right.
that we cannot, I think we all understand that. We just
Right.
need to be clear on how to educate.
Right.
And I'm a little concerned about construction being used and interpreted as design. And I think that's an important conversation.
Right, and it puts a strange scenario out there where they're saying, are we going to be in violation of QBS? Well, the ultimate idea, I mean, is that the board here doesn't make a determination as to whether or not those bids, whether or not that municipality was in violation of that.
But as John just said, we have to make the determination if our registrants are in violation of our rules.
Getting the question.
And we need to, as a board, we need to be
somehow.
proactive, and we need to understand, and I think we need to, the interpretation of these, if we haven't gotten an Attorney General's ruling on this, is that appropriate?
Well, I mean, you all, if you all want one, you can do an Attorney General's opinion on that. I think the preference from our legal department, from our point of view, is that with the same amount of time, we can provide an interpretive opinion. If you ask the Attorney General's office, whether you like it or, you're just going to get stuck with whatever they give you. But if we give an opinion, this is an opinion that we can give to you all. And we, sometimes we say, well, why do we need, the Attorney General's office is no smarter than our legal department, I'll put it that way. That's just kind of how our feeling is that you would get the opinion, and we would have to actually just abide by exactly that, and there's no way that we could move or stray from it. And if you tried to move and stray from that Attorney
Sure.
General's opinion on a different scenario, you kind of be stuck in this, well, should we go back and get another opinion based on this other set of facts, or should we get an interpretive opinion through your legal department here?
But with you us being presented with this FAQ, my assumption is that you have already made a decision about this. Or is that not correct?
No, I haven't looked at any
Ellery's
of that.
reviewed it.
Ellery
I
has
haven't looked at
reviewed
any of
this?
Yeah.
Okay.
So if you all are not comfortable with it, we'll just take all of that out, and we'll go back and.
Very uncomfortable.
I'm very
with it.
uncomfortable
Not to
with
do
it.
anything today, this is just proposals, so.
Robert, you have the floor.
Okay. So let me make sure that I understand what's highlighted and underlined in number 4. We've not published this to the public yet, correct? This
No,
is still
but,
for us to discuss and talk about.
Yeah, some of this information has gone out in response to questions
But number
we've
4
received.
has not, the
It
underlying
hasn't
part
been
of number 4,
published,
okay.
no.
I would like for us to, and I don't know if we need this in form of a motion, John, or not. I think, does TCA apply to public school systems and public building authorities? And I would just say yes, and let's go on. Because I think we'll win the construction battle when it comes to, if there's a delineation between construction and design services. If it goes to some sort of legal challenge, I just think there's enough of a difference there that I just don't know why. I don't know why we would put that in there at all. I think if a registrant comes in front of us that's put out a competitive bid on a school project, we need to treat them the same as somebody that's put a competitive bid out on a signalization project or any other kind of project that's a public works project. I think that's the only way we are consistent. And I know what this says, but I just don't think there's a huge delineation in my mind between construction and design. And you said before that you kind of were leaning in that direction. Did I hear that, or did I make that up?
I mean, for the way that I read it, when I read a statute, I try to read it just based on the words that it has in front of it. You know, is that what are the common meanings of those words if they're not defined, and try not to make it overly broad. I think the Attorney General's office, for some reason, has over the years looked at this a little bit broader in the sense, and I don't know, and I don't understand, I mean, I kind of understand where they thought that came from, but I wasn't sure as to why they went that direction. I mean, like I said, I don't think they're any smarter than we are. If you have route A and B, I guess they had been choosing B at some point in time. And I think, you know, part of the dilemma that I have, here, and is that this board is a little bit different. I'm not saying anyone's doing anything wrong. This board is a little bit different than what I'm used to, whereas most other boards don't attempt to give opinions, general opinions about their laws and regulations, you know, for people to rely on, because it just pigeonholes you into an area. It puts you in a corner where you can't get out of, so that what people say is they say, well, you may have said I was in violation, but I reasonably relied on some opinion that you had, and it was vague enough for me to do what I wanted to do, whether I was attempting to comply or not. There is a formal mechanism by which people can do that. It's called a declaratory order under the Uniform Administrative Procedures Act, where somebody could come forward and present you all with a question, and the question is usually, given this set of facts of what I'm doing, would I be violating your law? And they can come before you in a formal setting and receive an opinion from you all on that. It's probably never happened. It's happened on other boards before. But that is a formal way that the board can give an opinion, and it would be binding between the board and the person who requested the opinion only. It's just like the same as anybody going into the court and asking an opinion about something. But that's one way it could do it. I'm not dissuading you all from the practice that you've done in the past. I'm just letting you all know that I understand your frustration because I live with it. Because whatever you all want to say, we kind of have to look at and certify as to say, okay, whether or not we believe that this is, you know, within the realms of legal. And I know that's exactly what Ellery is attempting to do, but we cannot incorporate the whole. We can't make this is the end all of how QBS works, just in FAQs of a newsletter. I'm sure that when the Attorney General's office gave us stuff, we have decisions upon decisions upon decisions about QBS, which are pages upon pages. I mean, it's a whole lot more than just paragraphs that this board is trying to do. I think what you're all trying to do is to give clarification to your licensees so that they're, you know, feel a little bit more comfortable as to whether or not they would do something that would be in violation of the rules under that.
I guess, you know, my concern, and I'm on the board, is I, within the last few months, received a RFP from a school system. And in their RFP, they wanted fees and say that their selection of the designer will be fee, you know, part of it be fee-based. And then we've been publishing and saying the architects are not allowed, you know, we can't do that without being disciplined. And then, so I send that on to John, and the next thing I know, they're going, well, yeah, they can do that. And so it's like, boy, that's embarrassing.
Right.
You know,
You don't have the ability to put on top of your proposal is that this proposal is made in assumption that you are providing this proposal in compliance with this statute regarding QBS. If you find not to be in compliance, my proposal is hereby void, invalid. I mean, that would probably, if they brought that back to the board here, wouldn't you all say, well, they made a good faith effort to do what they were asked to do? Then again, everybody could put it on every proposal.
Wilson, you recognized?
A point of clarification, if I'm understanding what this paragraph 4 says and what you've said, there is a existing statute that deals for public school systems a specific way in which they can accept bids for any of their projects.
Right.
So our only choice, I guess, would be to appeal to the legislature or whoever to change the statute. But as long as that statute's in effect, we've got to comply with it as a board, it would seem to me.
Yes, Ricky.
I disagree that we would have to comply, but if the statute reads the construction of schools, because we all understand in the design industry, doing work, government jobs, that we have to do design that allows schools, when it goes to construction phase, that things have to be competitively bid. We understand that. We have to specify 3 types of equipment so that you're not sole sourcing anything. We understand they're talking about construction. And I think there's a lot that we can point to say that construction does not mean design services. There's a different, there's a contractors board and there's a architects and engineers board. So I disagree with if the statute says construction, that says that it applies to design. I think that could be very strongly argued. And I agree with what Frank said. If we don't answer 4 yes, there's a huge percentage of work that QBS no longer applies to that, as you said, cuts legs out from it.
John?
One thing I was going to point out, what you're saying seems logical to me, that construction wouldn't include design, but the fact, I don't have the statute with me. It's up in my office, all the thick pile that I have with all the AG opinions and everything. I didn't bring that with me. But the fact that particular statute contains an exception for energy-related services that include engineering services seems to me to imply that the legislature at least seemed to assume that that construction does include architecture and engineering services with the exception of those energy-related services. It's interesting to me that there's that exception in there for engineering services. And it mirrors the QBS statute. It says that those services have to be procured through qualifications-based selection. So the fact that does that make sense? That they carved out that exception seems to imply that it encompasses architecture and engineering. But I don't have the specific statute wording with me.
Is that the statute's exception, or is that the wording of this FAQ
No,
that
it's in the
Ellery worded?
statute.
That's the statute.
Yeah. And I'm assuming they carved that out when the Energy Efficient Schools Council was created. That's probably where that exception came from. They recognized apparently that was a problem, that those engineering services related to energy efficiency were being competitively bid, and that was perceived based on this statute, and that was perceived of as a problem, so they put that exception in there that those services had to be selected through qualifications-based selection, which implies to me that that statute was being interpreted previously as applying to architectural and engineering services. Otherwise, there would have been no need for that exception to be added to the law. That's the way I'm looking at it anyways.
Tony, the Brooks Act is what we based our QBS on, which is federal law. So does that not supersede what's going on right now?
Whether or not the Brooks Act would supersede these state statutes?
Well, the changes and such, if it says that we are supposed to be using qualification-based selection, with the exception of design services, to me, that doesn't, there's a conflict there.
Yeah, and you're asking very complicated questions. Well, here's the thing. I mean, this is what I keep getting hung up on, is that really it's not these sets of laws are not focusing on what engineers and architects have to do. It's focusing on what the schools and municipalities can do. So they may not be. Let's just say, for example, you have a RFP that comes out and says put a price on it, and you guys say I can't do that. That'd be in violation of QBS, and they say our lawyer says it's fine. We're not in violation of this. And then you say, well, are you sure? Yeah, we're good. Okay, and you send it up. And then somebody else says, hey, he sent up a proposal, Architecture and Engineer Board, he's in violation. He's in violation. We look at it and we interpret the statute differently than what the municipality did or whoever it is. Maybe they say we're not a public school or whatnot. And we hold them in violation, and then nobody actually files a complaint on that municipality. So we could actually hold our architects and engineer in violation. This is a bad scenario. You hold your licensee in violation, and nobody actually files a complaint, or nobody goes through and looking at the municipality as whether or not they were in violation. Because who has that's the question of who has the authority. I mean, do you see the whole, that's where I kind of get hung up at. I mean, there's, whether or not it is in compliance with federal statute or whatnot. Is another issue, and that would be the issue. That question wouldn't be for the licensee. That question would be for someone saying, for the municipality saying, hey, we don't have to follow this Tennessee statute because this federal thing is a trumping statute or whatnot. Does that make sense about the complication of it?
I think it's very complicated. I think they've opened a can of worms.
Yeah, from the lower tier, we're trying to help our licensees from the lower tier.
Right.
Interpret a statute that is not even meant to apply to the actions of our licensees. It's actually supposed to mean to apply to those, different municipalities. And if you can imagine, the state of Tennessee not only has each of its own municipalities and counties, but there are their own legal offices that are giving their own opinions about all of that. And we could show you the Attorney General's office opinions that we received, and they are not all encompassing. They are not all encompassing. It's actually a lack of. Is why we're here talking right now about it. So I imagine that your licensees out there could get RFPs. Here's an RFP, and they're all over the place. It really, and I'm sure that's kind of what it is right now. It's why it's all over the place, is that no one from the state has gone and shored all of this up and provided clear guidance to all of these municipalities and schools and whatnot as to whether or not, how do you interpret this statute. And and from a legal standpoint, oddly enough, oftentimes, is there any lobbyists in the room? Oftentimes the lobbyists will tell me, they say, well, it looks like this is ripe for some good litigation, and give me a smile. So, not that it's on you, but that's the truth of it, is that sometimes it just takes the courts to kind of sort it out sometimes.
No, Hal was first.
Just a question. So this has not been published, it's draft at this point, right? And no one is scheduled to make presentation on qualification-based selection. At least we haven't been asked to do that in the near future, correct? Would it be acceptable to the board to refer this to the communications and the laws and rules committees to perhaps hash out some of these things and maybe even interface with legal counsel on some resolution? Because, I've enjoyed the conversation. I think it's very informative, but I don't know that we can conclude anything today at this session. So if I need to make a motion, I'll be glad to. Opposed to us deferring it. Okay, I make a motion to refer or assign this issue, the qualification-based selection and the FAQs, to the Communication Committee and
Law and Rules Policies Committee. We don't have a communications committee.
the public outreach, right? Is that what is Steve's committee? Publications.
Publications.
So that'd be different.
Yeah, I would say
Sorry.
probably Law and Rules and Policies.
Thank you. I
yeah.
accept that. I will change my recommendation to the Laws and Rules Committee and ask that they interface with legal counsel on some updates for our next meeting.
We have a motion?
Second.
Motion and a second. Discussion? Philip?
Okay, that's the reason why I think maybe, how should I say it? But anyway, I'm gonna go ahead and say it. But, well, the intent is good, but we keep referring back to the committee is probably good. Let this be the last time we do it. So my question to how your intent was to refer back to the committee, look at it, the whole thing, or just to sort through the one that we have issue? Sounds like point number 4 is what we've been dealing with. I just thought that it might be good to give them some guidance. And I think our council is trying to give us some direction. I think sounds like the board is not comfortable until we vet this whole process out.
I don't disagree with what you're saying.
No, I'm just as a discussion.
Motion, to be more specific,
Yeah, I'm just asking, is that, you gonna ask everybody to look at every point again, or just need point number 4?
just as it relates to this issue, the apparent conflict, our registrants, and not put them in a position to be in violation if
I just want to be specific. Can you, yeah, thank you.
do I need to amend?
I think, is it clear? No, I think the amendment is good. I'm just asking for clarification. That's all in discussion here. Thank you.
I think in response that the Law and Rules Committee understands what the issue is, and we'll come back with a recommendation on whether that's going to say architects, engineers, or not. I don't know if my opinion is valid right at this point, but I don't think that's going to make the muster. Having the at least from the architect's perspective. So with that said, is there any additional conversation or comments on this motion? None? All in favor signify by aye.
Aye.
Opposed? The motion carries. Thank you, Hal.
We need to authorize a separate meeting for the committee.
I think we were going to schedule one for June anyways.
Yes,
so.
and we'll have that at that time.
Yeah.
Okay, I believe that,
Rick,
yeah.
might I suggest, I mean, this is putting off for 2 months, even getting started on this from the way it sounds, that everybody knows what the question is, and I think our legal counsel be able to present something at that meeting, and not y'all start asking questions at that meeting, present recommendations as to the method of resolving this problem.
That's a good point. Can
There's a
we-
meeting this afternoon at the law. There's
we're
not?
not. This is too encompassing for that.
Just to get started.
This has been
Clarify that.
going on for so long, I just hate to drag it on.
Forever and ever.
It's going to keep going on. Yeah.
Is there a reason legal counsel that
Yes, I think we can provide you all with an outline. You know, generally in these type conversations, what we can do is provide an outline of issues to look at and kind of maybe some guidance on interpretations on some sort of issues. I'll tell you up front, our office in interpreting this statute 124107, our interpretation of that statute 124107, we could give our interpretation on it, but it wouldn't hold water anywhere. I mean, does that make sense? I mean, our interpretation of it wouldn't be, no one would look at it. I mean, it would just be for the architects and engineers, and any way we interpret it, we could be, I mean, we could be completely wrong. The good thing is that if we interpret it, if you all interpret it one way, you could say specifically, hey, it looks like the municipality was in violation of QBS, but you know what? Our licensee did all that he could. And he was confused at the time or whatnot, and we could make it so that they wouldn't be in violation. Does that make sense? It's not to punish the licensee for attempting to do a good act. Yeah. It could be, yeah, I mean, it could be underneath the rule, but like, that's one of the recommendations that we could give, is that the rule could have it's possible that the rule could have a fallout provision where if you made your best attempts or whatnot, et cetera, you could basically get out of having been violated the rule. Does that make sense?
The test of it would be through a legal challenge. We would continue to act as if it would stand, and then until it's proven otherwise through some legal action, we're within our bounds to continue to administer it, are we not?
We could do it either way. You could make that there's a presumption that almost your idea there almost sounds like a presumption of guilt on my part. My thought, pending the outcome, or you could say there's a presumption that you've done it right until there's been some determination that the municipality was in violation.
I have a question on that. Who notifies the municipality that they are in violation?
I'd have to go back to the statute
I mean,
and read
isn't
the
that
whole.
the state?
I'd have to
I
go
mean,
back. I have to go
No
back
one?
and read the entire statute. I'm sorry, but I'm only looking at this section, and it's completely outside the realms of administrative law that we generally look at here. So I can go back and look at. That's part of what we'll do, is go back and look at it and tell you what is the end result on all of this. Kind of give it a more broad general look over so that we can have that information for you all.
My understanding is there's no enforcement authority in the statute, and that's the whole reason why we have the rule, is so that there's some enforcement authority for QBS.
Ricky?
I apologize. I got to offer this one more thought too, because this is a key, John, what you brought up about the exception there that you noted at the end of 4 about the energy-related services. I think that could be argued that proves the point that design was not part of this exception, because I think that what this has to do with is companies that are kind of quasi-contractors, quasi-engineers that come to a school system later that says, we can save you energy, we can do a study for you by doing these changes, that's been deemed design work. And so I think it could be argued that the intent of the law was that construction is separate from design, and that these entities that do this work kind of fall somewhere in between, and what this law was saying is that's on the design side. So there would be no reason you would put these people on the design side and then have the designers, the design industry, on the construction side. So I think you can offer it as proof that the design industry is not included in the exception.
Thanks, sir. And I'll get it. So you've got a motion to, have we seconded it? We did second that?
Seconded.
Okay.
This is discussion.
Okay, quick thing. One thing to look at, and I've got the statute pulled up here, it does say that construction management services are considered to be professional services. However, it says that qualifications shall be used and cost shall not be the entire factor. So it looks like in one level they're calling construction management service professional services. Why didn't they call that out in the beginning when they talked about construction? But since we've got a motion, I think the correct thing is to look at the statute in its entirety. I personally believe that we can carve out the word construction like we have traditionally looked at it, and still be able to at least bring this to our registrants to where they're not going out. And I think that continues this education process that we have. I agree with Wilson. We're never going to fix the whole thing. But if we can get people to start at least competing on qualifications and price instead of just on price, then I think we've moved that. We've given the public a much better product at the end of the day. So, and again, I think that's what we're here for, is to try to provide that to them. So, I would just like to go ahead and make sure that we are looking at that in advance, and I'll be glad to sit down with my brother Rick here and hash it out at a later date.
Let me ask a point of order, since we have a motion and a second, to send this back to the laws and rules. And as Laura said, can we get that information fairly soon with statutes and all that stuff we're talking about today. So members, do we just need to give it to the Law and Rules Committee, or does it need to be distributed to the entire board? So we can be more familiar with it and offer email comments. So at the June meeting, there will be a better understanding of what the board thinks that this should say.
Are you asking for more than just you want our product prior to the June meeting?
What, I'm sorry?
Are you asking for our product prior to the June meeting?
Yes.
So that whatever,
So we can be prepared at that meeting and not to belabor the discussion as we have for so long. I think we need to pull the trigger one way or the other. That's the consensus, I think.
I
of the
think
group.
the whole board should get it, then everybody will be able to see exactly what we're talking about and be able to render a real good.
I don't disagree with
decision.
that. I was just asking a question. Okay. All right. Not the week before the meeting, though. I mean, a little bit more. Yeah. Okay. We have a motion and a second. Any further discussion? None noted. All in favor of the motion signify by aye.
Aye.
Opposed, same. The motion carries. Thank you. Next item on the agenda is new business. Wilson, I believe that's you.
Chairman, the nominating committee met this morning. The nominating committee is composed, in addition to myself, of Rick Thompson, Susan Ballard, Philip Lim, and Bill Lockwood. We met this morning. The purpose of our meeting today is not to elect the officers, but to simply make a recommendation as to who we nominate. And we nominate Robert Campbell to be the chairman, Susan Ballard to be vice chairman, and Frank Wagster to be the secretary. That recommendation would be actually voted on in the June meeting, not today. So this is strictly a recommendation coming from the nominating committee.
Do you want to talk more to the reappointments?
Well,
issue?
yes, some of these nominees' terms will expire at the end of June, so hopefully the good news is by the June meeting, we'll know whether they have been reappointed or not. And if they have not been reappointed, then the board will have to go back and nominate some other folks that are still going to be on the board, but for the time being, this would be our recommendation.
We need any kind of a motion on that or not? It's just a committee report. All right, thank you. I know we're supposed to adjourn, but I've discussed something with John and council in regard to the Law and Rules and Policy Committee meeting and the Publications Committee meeting. The items that are published. Oh, I'm sorry. I'm getting ahead of myself. I'll hold that for later. Yeah.
You're on the roll. I hate to stop you.
Yeah, you pointed it out. Thank you. Okay, all right. Next subject's the correspondence from Charles Ferguson, RE Aerial Adventure Courses. I'm not sure. he's
That's on page 1, right behind the agenda on your iPads. Want me to kind of give you a summary of this?
We would, thank you.
Yeah, this is regarding aerial adventure courses. There's one being constructed in Franklin, and Mr. Ferguson is the architect for the project. And his question basically is, well, first of all, this structure, and you have some detailed information regarding the type of structure in the documentation here. It's like a ropes course, sort of. It's like 4 stories tall. Franklin's considering it an assembly occupancy, which of course normally plans would need to be sealed by a Tennessee registered architect or engineer, competent in the appropriate disciplines. But it's basically, it's like a manufactured product being that's provided by a company in Germany that does not have any Tennessee registrants on staff. So the issue Mr. Ferguson raises is, do we need to have a Tennessee registrant seal the plans for this project, or is there some other way that this could be handled, like by an architect or an engineer signing a review letter saying that it's in compliance with appropriate codes, et cetera? And Mr. Wagster reviewed the information and prepared a preliminary opinion that in his view, the design would need to be prepared by individuals registered in Tennessee, need to be sealed. And I've heard from Mr. Ferguson just this week that they do have a structural engineer on board now who is going to seal the plans. I guess maybe redraw them. I don't know the details of how that's going to be accomplished, but they do have a structural engineer now. But he still would like the board's opinion as to whether projects of this type would require a registered architect or engineer to seal.
Need a motion? Mr. Chairman, we need a motion?
Yes, we do. Can I get a motion?
That we accept Mr. Frank Webster's recommendation as appropriately submitted.
Motion, can I get a second?
Second.
We have a motion and a second. Would there be any further discussion? I have one question. If he gets the drawings and stamps them, is he in responsible charge? I mean, just to stamp some drawings provided to him by somebody else?
No, I don't think, yeah, no, he has to
Take the
he has to,
responsibility? Okay.
yeah, he has to redo them, if you want to say it that way.
All the calculations?
Yeah.
and- Yeah.
Yeah, he has to.
You couldn't just
design.
review the plans and seal them.
Yeah, the big concern here to me is, this is not a widget that you're adding to your drawing. This is the entire structure. It's an assembly occupancy, you could have as many as 250, by code, 250 people on that upper level there. It's a wood structure, et cetera, et cetera. It's not gonna meet any IBC codes, and they're trying to go back to, it's an amusement park structure. They say they'll go in and inspect it. Well, that doesn't, if you just look at it and see that the pieces are there, that really doesn't tell you anything. Good idea, but, the only thing I had, when I looked at it was the foundations had been designed. So, and by a structural engineer. And I was trying to figure out where he got the information for that, because it wasn't available here. Does it have snow load, wind load? There's nothing presented with this to indicate any of that. But if there's an structural engineer who's gonna take it over and take responsibility for it, then that's the way, about the only way I could see you could do that.
All right, that answers my question. Thank you. We have a motion and a second. Any additional comments or conversation? None being, all in favor signify by aye.
Aye.
Opposed, the same. The motion carries. Thank you, Frank. As the chairman, I would like to make a recommendation. Can I make a motion as the chair? Or just make a recommendation? Someone else make the motion?
Whisper in my ear, I'll make it. You want to move to Jim? I want to make a motion that we move the following two committee meetings that were scheduled for this afternoon, the Law, Rules, Policies Committee meeting, the Publications Committee meeting, to the June meeting at a time established by our executive director based on the schedules of the available committee members. How's that?
That's a great motion.
Second.
I have a second. Any additional conversation regarding that?
Call for the question.
All in favor signify by aye.
Aye.
Opposed? Thank you. That is, I think, all for the day.
Motion to adjourn, Mr. Chairman.
Second.
Motion and a second. All in favor signify by aye.
Aye.
Opposed?
Thank you.
Motion carries. Thank you. Good meeting, good meeting. A lot of good input. Now we